everyone and all the aspirants. Welcome back to Thorough Newspaper Analysis, which is brought to you by LawSikho. Let's see what articles we will be discussing today from the Indian Express and the Hindu. We are discussing today three very interesting and important articles, though in some other manner we have discussed them before as well in our previous sessions of news analysis. But today they have been discussed with a bit of a new angle, and we get to know a new points and facts about it. So that is why we decided to take them up again. The first one is contempt powers in the people's name. So this is an editorial which has been written in the Hindu, and the writer of this editorial has been written by Faizan Mustafa. And we would really recommend that whenever you are able to find any article written by Mr. Faizan Mustafa, it is actually very substantial and also directly hits at the law as well. Since he is the Vice Chancellor of the Nalsar, Hyderabad, that is why a very nice view has been presented in this article. Secondly, domicile-based job quota, the law, Supreme Court rulings, and special cases, and also jobs of the state. So basically, these are two articles. They'll be discussed in a combined manner. And as just yesterday we discussed that the Chief Minister of Madhya Pradesh has announced that now 100% jobs will be reserved for the local people only. So a lot of contraventions have arose to that, though it has not been a concrete decision till date. But yes, discussions are happening on them as well. And then finally, the third one is her right to property. As just very recently we discussed that now we knew that the women had been given the right of coparcenary, but now the Supreme Court judgment that has made it retrospective in nature and also given a stronger position to women. So we'll be discussing that in a further detail. And fourthly, we have the news and flash section, which is LawSikho's own initiative, wherein we try to discuss the important crisp news points that are more probable to be asked either in the prelims exam, or the facts and data quoted here can be used very easily and proficiently in your essay as well as your mains answer writing as well. With this, let's have a look at the LawSikho courses that we have for you. And here we would like to propagate you through this lot of the courses, which is the Judiciary Test Prep course. The link is there in the description box. You can definitely go and visit. And here on the landing page itself, you can find this free study material. So you can download it for yourself right now as well. Then we have other courses as well for CLAT, for All India Bar Exam, etc. So you can definitely have a look at them. We are very shortly coming up with the courses, full-fledged course of SEBI and as well as a UPSC Law Optional. So you can also have a look at that once it is into picture. With this, let's see that what is the multiple choice question for the day. Now, as we know that we always discuss a multiple choice question beforehand, before even we discuss the entire, content, so that if you know the answer, you may be able to brainstorm and jot down the answer in the comment section below. So the question is, which school of the Hindu law denied the women to be a coparcener? First, Mitakshara school. Second, Dayabhaga school. Third, both A and B. Or fourth, none of the above. Now here is the descriptive question for you all. Now, since we know that answer writing is a very important practice when it comes to cracking exams like judiciary and other competitive exams as well. So here is the question for you. Providing job reservation solely on the basis of place of birth or residence shall be violative of the right to equality and other fundamental rights endowed in the Constitution of India. Discuss. So you have to give your opinion as to how much do you agree with this, and if yes or no, you have to substantiate your answer accordingly. So the answer to this question has to be written within a word limit of 250 to maximum 300 words. And if you feel like, you can also jot it down in the comment section below so that we may be able to review your answer. With this, let's quickly jump into the discussion wherein we will be discussing about the power of contempt in people's name. Basically, very recently there is this legal activist, and also he has been a very famous advocate who is famous for filing various great public interest litigations, Prashant Bhushan. Very recently he has been involved, or he has been put down in a case of criminal contempt, that he has actually caused criminal contempt to the Supreme Court of India. Basically, I'll just give you a very short history to this. He had made 2 tweets regarding the Chief Justice of India, and On that ground, the Supreme Court means a contempt case, a criminal contempt case has been initiated against Prashant Bhushan. But now, a question that has risen very significantly here is that in the times of COVID-19, that this pandemic, it has just devastated the entire society and the entire social fabric. In such a scenario, there are a lot of cases that needed a lot of priority and more of attention from the side of the courts, and specifically the Supreme Court of India. But keeping all of those priority listed cases aside, the Supreme Court decided to first give its priority and attention to this case of criminal contempt against Prashant Bhushan. This definitely has risen a lot of questions in the minds of people, because this is actually showing that maybe the Supreme Court is sensitive towards its own, to say, dignity, or to its own prestige in the eyes of people, and it is actually ignoring the areas where its attention was most needed. Then the primary justification for the power of contempt was based on people's opinion. Now, basically, in this entire article, and also very recently, many articles have been discussing about the fact that do we even need to have laws regarding criminal contempt? Like, how much feasible is it to have laws regarding the criminal contempt? Because many countries that used to have criminal contempt laws, and even like the countries from where we were inspired to have criminal contempt, even they have become very relaxed and, to say, lenient in this regard. But India still follows a very strict and rigid format of criminal contempt laws. Basically, let's see that in which cases has the Supreme Court justified the power of contempt, that is the contempt power as protecting the public interest. So in the case of Brahma Prakash Sharma in the 1953, secondly Hira Lal Dikshit case 1955, S. Mulgaonkar 1978. Basically, many a times, and to see in the previous times, to say, there was more of this idea that criminal contempt is a good concept and the court should have the power regarding this. But now lately, the idea that has hopped in is that it is the the activities, the judgments, the observations that are done by the court that actually determine the image of that court in the minds of the people. And that is what determines that how much will the people have respect for that particular institution. And particularly when we talk about the Supreme Court of India, people actually desire that the court is active in nature, and further, it actually takes up the cases where people are basically suffering and they need any kind of respite in those matters. And to say, the cases of criminal contempt and so, they don't really matter a lot. And further, it has been observed that the courts, and specifically the Supreme Court of India, has been many a times exercising this power of contempt in the name of people, because then they say that if we do not take action against such criminal contempt, then the people of India, the citizens of India, will lose out onto the faith and the respect that they have for this judicial system. Well, that how much is it possible, how much is it the truth, has to be contested later on. But then again, what people aspire is the correct and efficient judgments coming from the Supreme Court, and that probably would be the biggest factor to reciprocate respect from the side of people. Now let's see that in which cases has the Supreme Court held that the criticism should not be taken up as contempt, and there should be a chance given to free and fair criticism as well. In the case of S. Mulgaonkar case, in Justice Krishna Iyer had actually said, so basically it was interpreted in a very different manner, but actually he had contended that contempt jurisdiction is not to be hypersensitive, even where distortions and criticism overstep the limits. So he basically says that the judiciary should not be hyper or oversensitive, and actually the merits of the case or merits of one's activities should be taken into account. Then Supreme Court in Shiv Shankar case 1998 and Rachapudi Subbarao case in 2004 said that criticism of the court that does not hamper administration of justice, which means that if there is any kind of criticism that has been made against any court, but that criticism is not at all hampering the administration of justice, so such criticism must be considered as a fair one, and even if not, then still it should not be considered as a criminal contempt, and there should be no punishment for such criticism. So basically, let's see that what are the gaps in the system. Firstly, the confidence, as we just discussed, the confidence of the people in the court is strengthened by the orders and the judgments and the active role that the court is playing into the society, and not merely by the law of contempt. Because then it says here, the maxim of res ipsa liquitor has been quoted, that thing speaks for itself. Once the people are able to see that the court Like, for example, the Supreme Court of India is taking very good judgments and is being very active in this regard, then the people definitely will have a sense of respect and dignity towards the court. Like, for example, when the Supreme Court had come with the triple talaq case and also the Sabrimala judgment, so these were one of those judgments that were highly applauded and highly encouraged and appreciated by the people. So then and there, the respect and the dignity that the court is actually asking for are restored. The court does not really need to have separate laws for restoring such respect and dignity for itself. Then excessive use of contempt by Indian judges. Now, as we know that they have been mostly taken as personal attacks on the judges. Basically, the power of criminal contempt should be exercised against the court. But many a times it has been done in such a manner that the criticism has been taken as a personal attack on the judges, which might or might not be the truth. And due to that, the Supreme Court and various high courts had approximately 96,000 civil contempt cases and 586 criminal contempt cases. So basically, this is a very huge number, and that should not be the case going on. With this, let's discuss the next article, which is talking about domicile-based job quota. Now, as we just discussed, that a day before yesterday, Madhya Pradesh Chief Minister, he announced that the government jobs in the state of Madhya Pradesh would now be in 100% manner reserved for the local people of Madhya Pradesh, and construing to this, no any person who does not belong originally to the state of Madhya Pradesh would be able to claim or would be able to get into this government job. This actually has invited a lot of controversy and discussion, though as we also clarified that this has not become a concrete idea right now. So it is only a proposal, and the whereabouts of this proposal have not been very clearly outlined by the chief minister. But yet this is a very big proposal to give, and also in many situations it will be controversial to the fundamental rights and violative to the fundamental rights that we have under our constitution. And first of all, this also needs to be understood that this has not been the first and ever, like never such instance has taken place. That's not the case. Many a times, many other states and other authorities also have tried to take such steps, but till date, most of them have been, nullified, and they were not allowed to be brought into actual practice. For example, in August 2020 itself, Telangana cabinet approved policy to reserve 60% of the people for in-skilled labor and 80% in unskilled jobs in new industries in the state itself. Then in July 2020, Haryana government approved proposal for 75% reservation in private jobs for local. Then 2019, back again, Kamal Nath government in MP itself had provided 70% reservation to domiciles, and in 2008 Maharashtra government had also done almost similar steps, and in 1990s Gujarat government had taken such steps. So basically, we need to understand that this has been happening since a lot of time. But yes, this is something to be celebrated, that never this thing was allowed, and hopefully this contention of MP government will also not be allowed this time as well. Now let's understand that what are the related constitutional provisions and precedents to this. Article 16 clause 3. Parliament enacted Public Employment Act providing for state reservations only and only in Andhra Pradesh, Manipur, Tripura and Himachal Pradesh. Now, as we know that under our constitution, some states have been given special status, just like we had been extensively discussing about Article 370 that gave special status to Jammu and Kashmir. Similarly, under Article 371, under various clauses of it, various other states of India are also given some special status. Now that may be in the field of education, employment, economy, etc. These could be these are various fields: jurisdiction, administration, etc. And similarly, states of Andhra Pradesh, Manipur, Tripura and Himachal Pradesh, by the means of Public Employment Act that came into being under Article 16 clause 3, had been given some reservation status and some reservation leniency for that matter. Now, as we know about Article 16, and here Dr. Pradeep Jain versus Union of India, in this case, domicile reservation policies would be unconstitutional. This was an opinion, but it did not give a ruling, as it was not a question under consideration. So basically, a kind of observation was seen in this case of 1984, in the case of Dr. Pradeep Jain versus Union of India, where an opinion was, though it was made out, that domicile reservation policies would be unconstitutional. Now here, one thing needs to be clarified very clearly, because now a question might arise that many a times the admissions into various education institutions are done on the basis of domicile. Also, many a times fees concessions are also given if the person belongs to the has a domicile of that particular state. Basically, under the Constitution of India and also in the eyes of the Supreme Court of India, domicile reservation in the field of education is allowed. So that is a difference. But it has not, please mind, it has not been extended to the domicile reservation in the field of employment as well. So once you're educated, then you seek employment or even otherwise. But for the case of education, you can avail domicile reservation in your own state. But in the field of employment, this has not been yet allowed. But yes, only in some cases. Now, as we know, there are exceptions. They have been allowed in some of the other forms. Then in the case of Sunanda Reddy versus State of Andhra Pradesh, which was a case of 1995, it struck down the policy which gave extra 5% weightage to candidates who studied Telugu. So yet again, we can see that there have been a lot of precedents wherein any attempt to give reservation solely on the ground of residence or place of birth have been stated as unconstitutional and violative of the fundamental rights of equality, then under Article 16, and thus they cannot be constitutional in nature. Let's see that what would be the future of this MP government stance that has recently been taken. And also there is one another case, Kailash Chand Sharma. In this also the Supreme Court invalidated the appointment of government teachers on the basis of domicile. So basically, domicile reservation is not allowed in the field of employment, though it is allowed in the field of education. Now let's discuss the third article for the day, though very extensively we had already discussed it regarding the co-parcenary rights of the women. So as we know that recently the Supreme Court order on co-parcenary rights of the women is a welcome step, but still we also need to make some attitudinal changes, some societal changes that deal with the attitude of the society. They need to be made. Now let's know that how is this judgment a good and a positive step. First of all, it has actually highlighted and also put down the patriarchal practices which were laid down through the Mitakshara school of Hindu law. Now, we really hope that you might have gotten the answer for your MCQ for the day, that which school of the Hindu law had proposed or it favored a patriarchal side of the society and women were not granted the rights of co-parcenary. So basically the answer is Mitakshara school. And then it settles the confusion created by two judgments. So earlier there were two judgments. Firstly, Prakash versus Phulbati, and second, Danamma Suman Surpar versus Amar. So in this, actually, the rights of parsimony were not granted to the women, but now we know that they have been granted to the women, even in a retrospective effect. Now let's see that what are the issues while implementing the judgment. So more or less these are societal as well as legal issues. So firstly is of the Stridhan. Now as we know that section 14 clause 1 of the Hindu Succession Act 1956 provides that women can acquire property as a full owner and retain it post marriage as Stridhan. Now here this also can be a very potential prelims question as to which property also endowed and also recognized by the Hindu law solely and solely completely belongs to a woman, and that woman even after marriage has complete authority and ownership of that property. So that is called as the Stridhan. So basically it could be anything. It could be a piece of property, it could be any jewelry, any amount of money, anything. So be it anything, if that is a part of Stridhan, she is the whole and sole bearer and whole and sole owner of that property. So the judgment might affect the anti-dowry laws as well. Basically because it is considered that the women should not be carrying or should not be taking away any dowry along with her, because that definitely it is illegal in India and also it is a societal wrong to say. But now if she would want to carry her Stridhan along even after marriage, that might be taken to be as a form of dowry in some or the other manner. Then secondly, right to possession may not be easy, because property transactions may not be easy in rural areas where property is in the form of agricultural land. So now we know, because here also some positive steps should be taken, because in rural areas, firstly, the awareness is very less. Secondly, it is very hard and very rare that women are actually given their right into the property. And thirdly, even if they want to take this right, are they even availed, or are they even able to avail the legal help or not? That should be made sure. And thirdly, societal acceptance, because the main hires might not provide compassionate rights to women, which will result in long legal proceedings. Because definitely, though it is a very celebrated decision, and the women are definitely celebrating it, and also a large section of men also for that matter, but still there will be a lot of males and other members of the society who are not appreciating this idea and would not at all be willing to give this right, or give the property to the women as a right, as a matter of compulsory as well. And thus a lot of work has to be done in this field as well. With this, we're done with the detailed discussion for the day. Let's see that what do we have for news in flash today. National Recruitment Agency. Basically, the union government has approved the creation of NRA, which is National Recruitment Agency. Now, as we have already given a tip to all of you, that there is no need to ratify or rote memorize any of these things. Just try to understand by the meaning of the terms. Basically, national would be for the entire nation. Recruitment means whenever you are trying to give jobs to anybody. So that is the process of recruitment. And agency means any institution that would be looking out into any prospectives. So basically, the National Recruitment Agency must have to deal with giving some kinds of jobs. Definitely, and that is why it has been approved by the union government for conducting a CET, which is Common Eligibility Test, for government jobs in the following three sectors. So currently it has been done for the three sectors. First, Railway Recruitment Board. Second, Staff Selection Commission. Third, Institute of Banking Personnel Selection, which is the IBPS exam. So these should be kept in mind. This could be a very potential prelims question as to this is into news currently as well. And then it will be held separately for three levels: graduate, 12th and 10th, and would be conducted twice a year in 12 languages. So this was all for this discussion. So stay tuned with LawSikho. We hope that it was a good session for you. Thank you so much, and good luck to all of you once again.